Otherwise, in the 30 minutes I have left, I'm going to try and make some swift progress through to the end. Ground 2, which is the deemed affirmation by a fluxion of time. I've already touched, well, I've already gone through the authorities and what we say in relation to the law on that. In relation to the judge's reasoning, we looked at this in my introductory comments, submissions, that the judge held at paragraph 137 of her judgment, which is core bundle page 183, that the continued performance and demanding of NHG to continue to perform the contract would have amounted to positive and unequivocal affirmation of the contract. But then in relation to effluxion of time, the judge dealt with this in paragraphs 141 to 143 quite briefly, and she held that a mere lapse of time, this is paragraph 143 on core bundle page 185, she held that mere lapse of time is not a positive act absent some further positive act of performance. And we say that those two findings are inconsistent. It wasn't a mere lapse of time, as the judge herself held, but there was positive performance going forward. And the judge's reasoning appears to be on the basis that she followed her decision in the previous case of Prakash, and where she held that a mere lapse of time, and held that a mere lapse of time, however long, cannot be a positive act for the purposes of a deemed waiver. But that finding was itself, we say, inconsistent with her previous decision in Prakash, because in Prakash she asked herself the question, well, whether the delay in serving a notice of termination was so long as to amount in itself to a positive confirmation. That we see in the authority bundle behind tab 38. That's in volume 2 at page 1194. The judge there asked the question whether the delay in serving the notice was so great as to amount to a positive act of affirmation in order to take the case outside the scope of condition 12.6, and 12.6 in that case was a no waiver by delay clause. So in Prakash, the judge recognised that a delay could be of sufficient quality to amount to a positive act to give rise to an affirmation. Yet, in her reasoning, brief reasons in paragraphs 141 to 143, the judge seemed to row back from that and suggest that any lapse of time, however long, could not amount to a positive act of affirmation. But in any event, we say that in finding that there was a mere lapse of time, she ignored her previous finding that there had been positive performance of the contract. So for those reasons, we say the judge was wrong to conclude that there was no deemed affirmation by a fluxion of time, because she failed to take into account the positive conduct of the contract. That's ground 2. Ground 3, my lords, is the construction point on clause 10.5. We've dealt with this in our skeleton, paragraph 60 to 69, in our supplemental skeleton, paragraphs 59 to 60. Going to the relevant clause, which is in the core bundle at page 318. The key wordings I outlined in my introductory submissions was the value of this contract to the supplier, and then further, as determined by the supplier acting reasonably, as notified by the supplier. Now, the points we make are brief as follows. The reference to value to supplier are words whose natural and ordinary meaning really refer to income earned by the supplier over the period, less the expenditure that it's going to incur. That is the value of the contract to the supplier. And the judge's point that parties could have referred to profit and provide the answer in that way is not a determinative point.
Did you mean it refers to income over a period, less the expenditure likely to be or to be incurred over that same period?
Yes.
So not profits per se, but a simpler calculation of what's due to me from now until the end of the contract, and what would I have to spend in that same period?
Well, it's a projection of their profit.
Well, but expenditure, I think that's a point made by the other side of it, but expenditure can be incurred at all times. It might all be upfront expenditure, and the rest might be net gain. So, which is it? Is it overall profit, or is it profit on this sort of cash basis of what I'm going to receive and pay over the particular period between now and the end of the contract?
Well, it's the overall profit over the period because it's the remaining value.
Yes. But what does that mean? Profit over a period. If you've already, let's say you've incurred half of the expenditure under the contract on day one, what's the profit remaining from the date of termination?
Well, the profit remaining will be to project what your costs are going to be overall at the end of the period versus what your income is going to be at the end of the period.
So you set against the remaining income all of your expenses throughout the contract, or a proportionate part of them?
It's all of your expenditure versus all of your income over the remainder of the contract.
Does that mean I understand the income is that which is left to come in, but expenditure is that's which left to be paid from here on in, or all expenditure?
It's what's left to be paid from here to the end of the period.
So it's a pure timing thing. You look at what I'm going to get in and what I'm going to have to pay out in cash terms between now and the end of the contract.
Yes. Now, to reinforce that, we rely upon the fact that there are various elements to this. The figures have to be determined by the supplier, and we say that indicates some sort of internal calculation. It refers to figures that only really the supplier can have access to. And the duty to act reasonably would not be necessary, we say, if it was simply a calculation of the turnover for the remaining period, because these are sums which are at agreed rates and could easily be calculated by both parties. So there would be no point for the supplier to be acting reasonably in relation to figures which are calculable by reference to information that's plainly there for all to see by both parties. Now, against that, we say that the calculation based on turnover gives URE an unreasonable windfall. As the judge found, URE did not forward purchase electricity. She found that at paragraph 185. And so, if turnover is the basis for calculation, requiring NHG to pay for the supply of electricity over the remainder of the term of the contract, when URE is not forward purchasing, presents a pure windfall to URE. Now, in her judgment, the judge referred to other costs incurred by...
The interpretation can't depend, can it, on whether, in fact, URE had forward purchased or not?
No, but at the time the parties entered into the contract, there had already been the arrangement between the parties for the payment up front for the electricity, or the supply of electricity, and the reason for that is because URE was not in a position to itself pay for forward purchasing of electricity. So when the parties entered into the contract, they knew, as a matter of fact, that URE was not going to be forward purchasing electricity. And so in those circumstances, if the termination payment is based purely on turnover, that lands URE with a pure windfall for the payment of electricity, which it was never going to be forward purchasing in the first place. We've also made in our skeleton various points about how elements of the alternative claim for loss, which was advanced by URE, which the judge didn't have to deal with, were set out in a schedule of costs, and we say, and it's difficult for your lordships to deal with this, so we appreciate, but we say in our skeleton argument that the various elements of those were simply not made out on the facts, and which if you take those out because they can't be established, the termination payment of sort of 3 million odd, or the loss claim for over 3 million reduces significantly, so that if one has a termination payment in the many millions, which is what the judge decided, again that leaves URE with a significant windfall, because it simply didn't suffer, we say, the losses that it claimed.
The loss damages claim,
yes,
wasn't based on loss of profits then? It's based on wasted expenditure, was it? Or yes, wasted expenditure.
No, it was based on it was a loss of profits claim.
When you say it wasn't made out, do you mean that's your case?
Well, the judge made no findings.
Because the judge didn't make any findings.
Yeah, the judge's reasoning meant that she didn't have to go to that point. So that's why I say I appreciate it. It's not something which is difficult for your lordships to contend with. So I appreciate the limitations of that. But what we said below is it simply wasn't made out. But if those losses weren't incurred, again we get the result that the termination payment based on turnover results in a pure windfall, and we say that can't be what the parties objectively intended, particularly when one looks at clause 10.7. Because they're the parties, we say, set out an intention that whatever is payable pursuant to 10.5 reasonably represents their losses, costs and expenses. So we don't say that 10.5 is a penalty in these circumstances because it arises upon a non-breach event. It's a non-breach termination event. But what we do say is that for the purposes of construction, if 10.5 is construed in such a way as to give rise to an unreasonable windfall in favour of URE, that is entirely at odds with the intention of the parties as set out in clause 10.7.
If we were to be in your favour on this point, what are you asking us to do? To try and work it out ourselves, or to send it back to the judge?
It would have to go back to the judge, my lord, because the judge made no findings on it. I mean, there was cross-examination and evidence led on this, obviously, but the judge made no findings on it. And if the clause was to be construed in the way that we invite your lordships to construe it, then there would have to be some process to determine what the profits would be. That should not, we submit, be a difficult task, bearing in mind that a schedule of loss was already produced by URE and documentation already disclosed in support of it.
That presumably would have been historical costs before the termination, is that right?
No, it was the alternative claim for loss was a loss of contract damages claim based on a repudiation of the contract.
Right.
So on that footing, a damages claim was advanced on the basis of the losses, i.e., the loss of profit that would have been obtained had the contract continued. So the process of disclosure and calculation has already been performed.
I'll just ask you about your submission on the point about the 50% of the remaining value, because this clause covers breaches as well as non-breaches. And I think the consequence of your argument is, putting it in very general terms, that the result of the clause would be that if I can call it the innocent party here, would end up getting only 50% of what it would normally get on a damages claim. Is that right?
Yes, Lord, yes.
So when one then looks at clause 10.7, which you've just referred us to, actually it wouldn't be a reasonable estimate of the harm because it would be 50% of the harm.
But I mean, our argument on that, as you lordship have seen, is that the upside for the innocent party, to use your phrase, is that there's accelerated receipt.
So remaining value means an undiscounted sum, does it? Based on what would have been the income less the expenditure for the rest of the contract.
Well, it's 50% of the remaining value, but that is payable within 10 days.
But the question I was asking was whether that's then an undiscounted sum.
The remaining
value, which you say is the difference between income which would be earned after that date and expenditure after that date. You say you just take those sums and then that gives you the remaining value and then you pay 50%.
Yes. Yes. And my learned friend says that, well, that's a reduction that wouldn't be agreed. We say, well, it's justifiable on an objective basis because it's payable within 10 days of termination.
Right.
And
conversely, if value would need to be discounted to a present day value to take account of early receipt, that would be something which some sort of calculation would be needed for.
yes.
Can I go back to this point about profits, particularly anticipated profits? So I understood the judge to have considered that the parties did not believe the short-term contract was profitable at all. That was the argument made by one of the parties, and at paragraph 185, the judge refers in passing to both parties knew that it was only the precursor to a much longer contract where any profits would be generated. So I got the impression that her understanding was that parties understood this would not be profitable. Is that wrong? First of all, was that a wrong as to their understanding? And secondly, did it turn out to be wrong because there were, in fact, there would have been profits, hence your loss of profits claim, or the loss of profits claim?
Well, yes, I mean, we're not sure where the judge gets that understanding from, or the finding from, in terms of parties' understanding would not be profitable. The contract was as a prelude to the long-term contract. And this is another area where we say the judge made an error, because the costs of the business of URE of setting up the business in order to perform the long-term contract were not costs which we say are referable to the contract. In terms of whether or not this contract was profitable, we say there's no basis for the judge to say that the parties understood that it was not going to be. And it's not entirely clear where that comes from. It may be that subjectively URE might have taken the view that it was not going to be profitable as a matter of their long-term business, that their first 4 years were not going to be profitable. But that's not something that necessarily both parties understood. But we say on any view, the value to the supplier are the key words which point to this being a profit calculation as opposed to simply a turnover calculation. And yes, to your Lordship's other point, the fact that a loss of profits calculation was made is a strong indication that there must have been some understanding of profitability in the contract. So those are our submissions on ground 3. My Lords, in relation to URE's additional grounds, I just want to say a few very brief things. We've covered them in our skeleton argument. But in terms of the interpretation, ground 1, additional ground, the interpretation of the words "at any time" in clause 10.2, we say that the judge was absolutely right in her interpretation of this. The finding, relevant findings are at paragraphs 129 to 140 of the judgment. For present purposes, I would simply submit that the judge's reasoning there is impeccable. Then the second of the additional ground, which is the finding that URE communicated its elections. That's the finding of paragraph 137, which we've already looked at, namely the positive continued performance of the contract. We say that that clearly is a finding of fact that was not plainly wrong or rationally unsupportable. and it's certainly not a finding that no reasonable judge would have reached. In any event, whether conduct amounts to an unequivocal communication of election involves an objective assessment from the perspective of a reasonable person in the position of the counterparty, and that's how the judge viewed essentially the continuation of the contract. That test, for your Lordship's reference, is that objective test set out in the ICCI versus Royal Hotel case, the judgment of Mr. Justice Mance, and it's at page 163 of that report. That's Authorities Bundle, tab 17, page 494. And then also, if I could refer your Lordships to the judgment again of Mr. Justice Foxon in SK Shipping. That is Authorities Bundle, tab 34, so towards the end of volume 2, at page 1073. And paragraph 225 at the bottom. Where the judge there deals with communication. At the top of page 904 internal, Mr. Justice Foxon held that if delay, this is 4 lines down, he held that essentially if delay can amount to unequivocal communication of an election, well then so can conduct which is affirmatory of the contract. I'm not quoting verbatim, I'm summarising what he says there. So,
and none of this was affected by anything in the Court of Appeal?
Lord, no. Not that fine, not aware of that. So, but we say that if viewed objectively, the continued supply of electricity, the requirement for NHG to participate in the rollout of smart meters to pay for electricity, all of that objectively was conduct aimed at continuing to perform and uphold the contract. And it was therefore entirely right for the judge to view that sort of conduct as being an unequivocal communication of an election. In summary, it was a finding of fact that the judge was perfectly entitled to make and was indeed correct to make. So, my Lords, unless I can assist you any further, those are my submissions pending reply.
Thank you very much. Mr. Sims.
My Lords, what I propose to do is to try and break down our submissions under 3 different headings. The first is on the question of knowledge, which obviously raises the issues under ground 1, and at the same time deal also with the law in relation to ground 2 and also the response notice points, because obviously the case law deals with all those points together, so it makes sense to take those together. The second heading is, of course, the question of unequivocal communication of election conduct, which engages ground 2 and the response notice additional grounds. And then heading number 3 is dealing with clause 10.5 and interpretation of clause 10.5. You will get the benefit of my learned junior, Mr. Wibberley's assistance on clause 10.5, so he's got to address you on clause 10.5 to give you a break from my voice and hear a different voice on that, and that'll probably be tomorrow morning.
Very good, we'll look forward to that.
So, my lords, then in those circumstances, dealing with waiver by election and just some introductory submissions and observations in relation to that. Really the fundamental issue on this part of appeal is in what circumstances does a party lose an express contractual right, which the parties have agreed to terminate, where, number one, no time limit was placed on the exercise of that right by the contract. Indeed, as I'll come on to in due course, here there were specific wording in relation to that, which we will come back to. But two, there was no later express agreement between the parties that the right would not be exercised. I put in brackets with or without consideration being not a part of that discussion. And thirdly, of course, no consideration has been provided for the loss of that right. And fourthly, no detriment has been suffered by the person seeking to rely on the doctrine due to any complaint of lapse of time. Indeed, on NHG's own case, as set out in their counterclaim, and if you want the reference for it, it's paragraph 58 of page 318, they positively benefited from the period of delay because the price they were getting on the contract was favourable to them. So those are the background facts against which they rely on the doctrine. And I put the point in those stark terms to respond to NHG's central argument that their position favours contractual certainty. In our respectful submission, it does no such thing. The doctrine on which NHG relies is a common law fetter upon express contractual rights. It is a potential source of uncertainty, and unless kept within carefully defined, calibrated bounds, a potential source of injustice, because it is dealing with the situation of a loss of rights on a non-consensual basis without consideration being provided. It's because of that potential injustice that the doctrine of waiver by election has been, and our respectful submission should continue to be recognised in accordance with the narrow and well-established principles which we can see derived from most clearly the decision of the Court of Appeal in Payment of Jani, but which has been followed and understood to apply that principle generally across the board as a matter of common law principle, irrespective of whether or not the source of the rights in issue are contract or otherwise. And in reality, what the submission in this case is to introduce, in our respectful submission, a reading of Payment of Jani, which just simply doesn't sit with the general tenor of the observations in that court, that they are seeking to rationalise a general principle which is applicable generally, but moreover introduces considerable problems in terms of its practical application, because on their case, as I understand it, as articulated by my learned friend, the central thrust of the theme is that a party is deemed to know the rights under their contract. So the logical consequence of his argument must be that that is applicable not simply to contractual rights in relation to termination, but to all other rights in that contract, unless he's urging on this court an even further salami slice approach. And in those circumstances, you end up with this odd scenario where, in his case, the facts giving rise to the breach fall into one category. Knowing it is a breach falls into that same category, unless, on the third category, it's an express contractual right to terminate. And the reason why I put it in those terms is because he is saying that this principle does not apply where you have a general right to claim a repudiatory breach. I just don't understand how that can work as a matter of practical application, that the first instance judge is going to have to hop between, on the one hand, I need to ascertain what the actual knowledge was in relation to everything but simply the right to terminate. But what is the principal basis for dealing it in that way? In our submission, you don't get from Claimant and Lajani, or indeed the Commonwealth authorities that he refers to. In our submission, what Claimant and Lajani has been understood to establish, whilst it has its critics, they nevertheless, in that criticism, recognise this is what it has established. Having considered the potential different lines of authority, is that in order to have the requisite knowledge, and put to one side blind eye knowledge purposes for present purposes, but in order to have the requisite knowledge, the party must not only know the facts giving rise to the right, but also that indeed triggers a right, if I can put it that way. And the reason for that is logical, and it's logical because if you are justifying a departure from a situation where you are in effect telling one side, we are removing one of your contractual rights, you have to have a clear basis to do that, rooted in the conduct and behaviour of the party who's losing that right. That can be referable to the situation where they have an informed choice scenario. In other words, they know they have a choice. There's a different category of case, which I think my Lord Justice Miles alluded to, of not understanding the consequences of what follows thereafter. But at its heart, as soon as you break the connection with a knowledge that you have a choice, then there really is nothing left of meaning in the principle. As regards my learned friends contended for exclusion. And it would require a re-rationalisation of a number of Court of Appeal authorities, as well as first instance authorities such as Tele2, VDW, Involver, TCG Pubs, and DD Classics. Now, if the court is with us on that central submission, then it's a relatively short point. But the broader point, insofar as this court is persuaded that this point is in fact open to pursue, it is something which we would say fails to recognise some fairly fundamental points, which I'll just briefly summarise. The first is that there are two distinct doctrines of waiver. The common law doctrine of waiver by election and the equitable doctrine of waiver by estoppel. We, of course, in this case, only concerned with the former, being the common law doctrine, which is the more stringent because, or the narrower, because equity obviously exists to mitigate the harshness of the common law, not vice versa. The factual scenario we're therefore dealing with in this case, and it's important to have this firmly in mind, is of a counterparty who can't complain that they've suffered any detriment as a result of any delay, who in fact, on the facts of this case, had it in their hands to approach the counterparty for a discussion in relation to whether or not we consented to amalgamation in advance, but did not. And yet itself is turning around saying, even though it's not suffered any detriment, we should take away this contractual right. And the drumbeat for that is it's said to require certainty. But the certain position is what's set out in the contract. The certain position is that they conferred a contractual right on URE in those circumstances. So I'll come back to the mere shipping point in due course, but if you look at mere shipping in the context in which the observations were made by Lord Hamlet, that was to reject the submission of the party who was not rooting their arguments to anchoring it to the contract. It was the opposite way around, so the way my own friend is seeking to do it here. Secondly, for waiver by election to arise, and again putting to one side the case of blind eye knowledge, the putative waiver must have actual subjective knowledge of both facts giving rise to the right to terminate and of that right itself. That's accepted by my learned friend as a common position on this appeal, subject to the exception, the carve-out that he contends for. And another way of putting that is the basic proposition is that where there are two possible remedies or courses of action, at which to the knowledge of X are open to X, and X has communicated their decision to follow one course or remedy in such a manner as to lead Y to believe a choice has been made, they will not be permitted to resolve from that position. Now, the question of communication, the unequivocal conduct, is assessed objectively. But the question of knowledge is, of course, a subjective one. Thirdly, save where provided by statute. That's a requirement. There's a matter of authority, but also first principles. On the face of it, it seems to be recognised as applying to all cases of all types. I'll come back to this in the context of Claimant and Jali in due course. And the cases are dealing with termination at common law and also pursuant to express contractual rights. See, for example, BBW. The differences in treatment seen in some cases, which obviously deal with in detail in due course, in our respect for submission, can properly be rationalised on the basis that they're dealing with evidential presumptions developed to mitigate the forensic difficulties litigants may face in proving actual knowledge. Fourth, if a difference in approach were to be justifiable, then as a matter of principle, a party seeking to exercise a contractual right to terminate should, in our respect for submission, be treated more favourably than a party seeking to terminate at common law. A common law right to terminate only arises where a party acts in a way antithetical to the continued existence of the contract. This gives rise to an obvious choice in the sort of typical rescission scenario between termination and holding a party unwilling or able to perform to their bargain. The two are necessarily inconsistent. There's a stark fork in the road. But the position on the contract here is in our respect for submission, more nuanced than that, even if you put to one side the provision in relation to arguments in relation to response notice points. On certain events occurring, the parties agreed that URE had the option to terminate, but there's no inherent inconsistency between the existence of that right and the continued operation of the contract. Fifth, any test that does not involve actual knowledge is liable to elide common law and equitable waiver and their requirements, rendering the latter largely irrelevant in this context, because obviously the latter requires detriment. And if my learned friend is right, people will be relying on common law right waiver without needing to show any detriment. So you have a more favourable position under the common law than an equity. I repeat my submissions about how that's the wrong way round. Sixthly, if knowledge is established, there must be words or conduct that assess objectively amounts of clear and unequivocal communication that a choice has been made. And part of NHG's appeal in our respect for submission seeks to confuse this second stage with the first. we respectfully endorse the observations made by Lord Justice Miles that the clear prerequisite, if you like, is there before you then get to the second stage. When you get to the second stage, in certain circumstances there can be a deeming when there's an affluction of time. That makes logical sense because the second stage is an objective exercise looking objectively at the conduct. And indeed, we would respectfully submit that that sits uneasily with the notion that in reality my learned friend submission is that in the contract context the first stage is objective too. It's in fact constructive knowledge. Seventhly, because what is being communicated is a choice which has been made, relevant conduct must be conduct in relation to the contract said to have been affirmed, not wider factors. And this leads to our point in relation to our response notice grounds 2, that we say that the factors the judge identified were in fact nothing to do with actually performing the contract itself. 8th, URE is not relying on ignorance of a right as a defence. It is NHG who is relying on the doctrine as a defence. Instead, very simply, URE is relying on the contractual right bargained for and triggered by a solvent amalgamation which they could but didn't seek to consent to obtain the consent of URE in advance. So it's in our respect submission wrong to suggest that in some way this fits into the category of law of ignorance of law is not a defence. 9th, there is no harshness to NHG. If there were any harshness, it would have been evident in the Stockel case. Moreover, if the harshness is said to be the difficulties in relation to proof, that has been alleviated by the presumption where legal advice is sought. And 10th, in suitable contractual cases, it may well be that a strong, almost irrefutable evidential presumption may arise to assist the person pleading an election. That's an evidentiary point, not a doctrinal difference, if I can put it that way. The facts of this case were unusual. The clause was triggered in circumstances where NHG don't seem to have addressed their mind to its consequences. Mr. Ensel didn't. You've seen the findings of fact of the judge. And the judge made findings that he didn't do so for good reason. In the usual case, the contracting counterparty will find a sceptical first instance court, probably adopting similar language that we see in some of the land intent cases and Lord Justice Stevenson in Payne and Jani. Really, are you trying to say that you didn't know what this customary term meant in the contract? That, in our respectful submission, is a way of calibrating the law to deal with any potential difficulties or harshness which may arise. But it would create substantial injustice if the court were to include within that bracket the category of case where clauses are genuinely difficult, uncertain, unknown, and yet they're treated as being lost. Bizarrely, in this case, in the circumstances where the counterparty to the contract was arguing for many years until we actually disposed of this point on the summary judgment application, that the contract wasn't in fact triggered, and that Mr. Ensel was right. Now, there's obviously the threshold point of this argument which my own friend has sought to develop on this appeal was present before the judge, whether as a matter of pleading or as a matter of case advanced. In our respectful submission, it's perfectly clear from reading the judgment that it wasn't. And in our respectful submission, the litigation below would have been very different if the point had been taken. I'll come back to this point in due course. But in our respectful submission, the reason why it wasn't taken is because actually the discussion in Payne and Najani and the principles summarised, for example, in Telly 2, which the judge in effect refers to in her judgment, and the parties didn't have any argument with before her. And in our respectful submission, there is something which brings the appellate process into somewhat disrepute. If a counsel can turn up before the Court of Appeal and criticise the judge for getting something wrong in circumstances where they haven't actually run that point before the judge. And that's why, in our respectful submission, you see in the authorities which will come into in due course, that obviously there were the well-established three principles of single tax, but there's also the principle in the Prudential case, which is referred to by Lord Justice Lewison, that then there needs to be some good explanation as to why the point hasn't been raised at first instance. There may well be some good explanation in certain cases as to why the parties don't. But here, there isn't simply no good explanation. There is no explanation. They're just not condescended to give an explanation at all, but instead of double down on the submission that this was all clearly before the judge. Ground 1A clearly wasn't. On grounds 1B and 1C, on ground 1B, I think is the debate as to his understanding of knowledge, and we respectfully adopt the exchange between my Lord Justice Zacaroli and my friend in relation to what this is getting at. And I'll take you in due course to a passage in my own friend's closing submissions where he uses the two phrases interchangeably as well. There is nothing in that point if there's nothing in ground 1A. Ground 1C, I think, is the obviously available knowledge point, which was before the judge on the basis of a blind eye knowledge approach based on cases like ICI, Mance, an early authority, but which was firmly rejected by the judge in her judgment. It wasn't simply a case of the judge making findings which are not supported by the submission made by my own friend, but she made positive findings which are flatly inconsistent with such a submission before this court on a blind eye knowledge basis. And really what he's seeking to do is, through different ways, to leave open a wider category of case out of a passage in Cosmar, paragraph 74, which with respect doesn't bear the weight he seeks to put on. So those are the points by way of introduction and observation. Now I was going to deal with points of law before then coming back to the grounds of appeal. On the points of law, there's much between the parties which is not controversial, it seems to be recognised that I think everyone recognises this, that the position in relation to Canons needs to be treated with some care in view of it proceeding in Payne and Najani, and Payne and Najani obviously approaches the interpretation position having regard to a close analysis of it. The relevant principles more generally, before we get to the question of the carve-out, again, I don't think there's any significant dispute between the parties in relation to these. The judge set them out in her judgment, but also a very similar summary is in paragraph 53 in Telly 2. It is settled as a matter of general principle that only actual knowledge will suffice, or blind eye knowledge, and you see that from later cases as well, such as Mr. Justice Mance in ICCI and Royal Hotel. It's just worth briefly picking up on a passage in ICCI and Royal Hotel, however, for one point, just to drive the general point home, as far as what we're dealing with here in relation to the species of knowledge. If you could turn to, it's behind tab 17, which I believe is in folder 1, And it starts at page 482. The particular passage in mind, if we can fast forward to 492, please, is the discussion of the law. Right-hand column, it's internal, page 161. And you'll see the sideline passage marked, and you can see reference there in Chitty on contracts to what's said about the principle, and then an explanation by the judge as regards how that needed correcting. And then he goes on to say over the page, dealing with a special problem of a deliberate and conscious decision to avoid knowledge, which is really what that case then sought to explore in further detail. But if we just go over the page, right-hand column on that page, you'll see that the distinction between estoppel and election is summarised in an aspectful submission in correct terms and accurate, pithy terms there, which is the essence of it, is dealing with a choice. And then over the page at 493, sorry, still on 493. You see that the passage we're dealing with here, in effect, what Ms. Justice Mance is saying is that this is effectively a jury question. The findings of fact to be made as regards the state of mind of the counterparty in the context of election. It is a fact-finding process for the first instance tribunal. The one limitation to that, which is recognised in the law, which you see expressly recognised, and which we've already touched on, is the limitation recognised in Canons at 883b as articulated in Palin and Jani, and can also be seen and noted in BDW. And it's worth briefly, I think, turning up BDW. I don't think we've looked at it yet. That's in second folder.
Are we coming back to ICCI, or have we finished with that?
I finished it for the moment, yes. Yeah.
What page are we looking at now?
So the particular page in BDW, relevant part that we're looking at is, well, it's worth, first of all, just looking, sorry, I didn't give you the references, just if you need it, it's tab 25. And the first point just to note is the clause, the relevant clause in the contract in this case is in fact the one in paragraph 10. It's a fairly lengthy quotation, but the key part of it is the proviso, which is marked at the bottom of page 735, the continuous pagination. And so far as the discussion and submissions in relation to election are concerned, they start within the judgment at paragraph 65 at page 749.
So is this a contractual right case?
Yes.
So what sort of this is a lease, is it?
This was there was an underlying lease, but then there was a contract in relation to a purchase of sort of a development in relation to a scheme of different properties. So it rose in the context of there being a lease and a break clause as well, and as part of the background facts. But the key provision which was engaged in this case was to do with completion of the particular purchase contract. You can see in paragraph 10, 6.2, with an entitlement to refuse to complete to purchase until such time as, and then you can see the proviso, provided that the vendor or purchaser should be entitled to rescind this contract by serving written notice. So this is an example of a case where there's an express provision for entitlement to terminate within the contract which is being considered. We'll come back to the question arising in Payment and Jani, which I think my Lord Justice Miles raised as regards what was going on in Payment and Jani. But here you can see quite clearly that it is recognised as a contractual provision. And the submissions as regards waiver were engaging the question of whether or not that particular provision was engaged or not. And you see in particular the focus in this case on the ability to rescind the contact. I think that should probably be contract within paragraph 66 at any time. So that's the operative provision within the relevant clause. If you turn back to it in the proviso. If you go back to 735, you can see the proviso is by serving written notice on the vendor at any time if the matters referred to in paragraphs 1 to 6 above have not occurred within 5 months of the date hereof. And so we get into the judgment where there's a discussion about election and whether or not that's engaged or not. At 68, you can see the quote from Cummings and Lord Diplock. And if you then follow that through, there's also then obviously discussion in Payment and Jani, which is quoted from, which we'll come back to. And then we can see the judge's findings at first instance are set out in paragraph 71. And you see in particular the passage within the judge's judgment at first instance of paragraph 125, where he concludes there's nothing in the evidence which in my view showed that Barrack acted in such a way, nor was it ever put to them they had consciously or unconsciously exercised their rights in a way which was inconsistent only with giving up their rights. And the submissions were then taken on appeal that analysis disclosed a number of errors of law. And he submitted it was not necessary to be some kind of considered decision to elect between inconsistent rights. And other criticisms made of the judge in paragraph 73 and 74. And then you then have the reasoning of Lord Justice Patton starting in paragraph 75. And you can see in paragraph 75 and 76 that he's drawing a distinction between knowledge of the right and turning one's mind to it. And in this context is clearly drawing the distinction which we already discussed deriving from canons between knowledge of the consequences as against knowledge of having the right. And then there's then discussion about the classic and common situation in which a party is put to an election of the kind described by Lord Diplock, and that's obviously situation where there's a repudiation and they're considering whether to terminate the contract or affirming it and waiving the breach. And he goes on to make the point that the continued performance of the contract is ipso facto likely to amount to an affirmation of the contract. The innocent party is necessarily put to the election. But then goes on in 78 to then deal with not all rights to terminate a contract in these circumstances or have the effect of putting the party with a right to rescind to an immediate election. And break clauses as being an obvious such category. And I'd invite your lordships to read paragraphs 78 and 79.
That seems to be saying that although Barrett did have, or should be taken as having knowledge of the right to rescind, the particular right was one which didn't have to be exercised straight away, and therefore they were not faced with an alternative, or with alternative courses of action. It was consistent with continuing to perform the contract, was consistent with maintaining the right.
Yes. And so our point really is a short point. The reason why I've taken this point right at the outset is because it's easy to sail into the assumption that simply because you're dealing with the termination provision in the contract, you're automatically into election territory. And the logical first question, really, even though it may be said to come later in terms of the grounds of the response notice, the logical first question for your lordships is, having regard to the terms of the contract, is this truly a case of an action in the stark terms you see in the repudiation, breach and rescission cases, or is it at the break clause end of the spectrum, if I can put it that way? And BDW, of course, also shows that in this context, and I accept the point wasn't argued and disposed of by the court here, but clearly everyone is proceeding on the basis of the law of doctrine of election applies across the board. You can see that in all the cases that we deal with thereafter, certainly in this jurisdiction. So shall I turn now to Payman Lajani on the assumption that we are truly in this sort of election category? Obviously, that's the assumption as to why we're looking at Payman Lajani. And your lordships have that in file 1 behind tab 14 at page 319. There's a fairly complex factual background to this. There's obviously the head note is a useful summary. There's also a summary of it in Wilkin and Garley, one of the practitioner's texts, which we given you, which if you want the reference for it is at 419, and that's in the authorities bundle behind tab 58 at 1870. But in short, for present purposes, it was concerned with rescission of a contract for the assignment of a lease of a restaurant where there was an undisclosed latent defect in the assignment's title, owing to an impersonation taking place in the sequence of events which transpired. So it was Langiani's use of impersonation when seeking to take the interest from the landlord. That was a breach of a contract in this case. We don't have the national conditions of sale before us as regards the conditions which were in place at the time. And on the face of it, the decision-making process does appear to have been on the basis of rescission under the general law rather than under the contract. But, just pausing there, it's not difficult to envisage a scenario where, in effect, the two will be the same, where you have a termination provision which provides for rescission, as indeed was in the BDW case. In fact, for modern contracts, probably it's more likely that the two will be spelt out, even if we can't discern from this case whether or not there was actually an express contractual right of termination. Now, the discussion on waiver, your lordships were taken mainly to the judgment of Lord Justice Stevenson. I'm going to take you back to that just to highlight a few points arising out of it, then also look at the other concurring judgments of Lord Justice May and Slade, which are also informative. So your lordships have them, the contractual provisions which they appear to be looking at are referred to in Lord Justice Stevenson's judgment. It's appear at the bottom of page 465 internal report or page 327 of bundle. The issues are then identified as in effect split into two by Lord Justice Stevenson. He starts beginning to consider the issues at the bottom of page 477. And he then analyses the negligence case, which we don't need to dwell on. And the affirmation issue starts at page 481. He looks at the judgment below and then starts his reasoning. And the first line in the reasoning is to emphasise the generality of the principle which is being applied. We invite you to note in particular between F and G the words, a man may have a right given him by his contract or by statute or by common law, and a right to choose whether to enforce or waive that right. And then indeed in this case, the contractual rights are then spelt out as regards interpreted here by Lord Justice Stevenson as giving a right to rescind should the landlord's licence be refused, not available within 8 weeks of 2nd of February 1979. So clearly what he is contemplating here is a contractual right which is being triggered. We then have discussion about other categories of case, so lease cases, and then obviously the statutory Workmen's Compensation Act cases, and then obviously sale of goods being another. And over the page, at 482.
Sorry, I know that I've made this point before, but I'm still troubled by what the right was that was being exercised in this case. Well, because that passage suggests that it's actually a contractual right to rescind which is being exercised. And looking back at, I was just looking back at page 466, because this refers to the 8 weeks period.
Yes, but clause 9. of
Clause
course.
9 refers to the contract being conditional on the granting of a licence, etc. And then if it's not done within the 8 weeks, then
No, you're quite right.
the party may rescind its contract by notice in writing. And that passage you just referred to seems to be a
Does refer
reference
back
back
to
to that.
paragraph to clause 9. You're quite right.
So I'm wondering whether this is in fact
Yes.
a case of a contractual right to rescind.
Yes. No, I think you're right.
But I may be wrong about that. I'm just
Well, it
trying to understand what the case is actually about.
certainly, if we will go through the judgments in due course, but they talk about rescission in general terms. There are two ways you could potentially interpret it, I suppose. One is simply on just a right to rescind on the basis of an impersonation type process, which might give rise to a common right. But yes, under clause 9, you're absolutely right that does contractually provide for a right to rescind, and that is indeed the. So I should probably withdraw what I'd said previously about it simply being a common law right. That what they are contemplating here are contractual rights, and indeed a contractual right to rescind. I think you can probably also get a similar flavour if we just, on this topic, just skip to Lord Justice May just to see how he puts it. As he adds some observations of his own. I think really that discussion is at page 494, internal report at page 356. Certainly my reading of that passage, in particular the part where towards the end of just below C, says, for the purpose of this judgment, I'll confine myself to the case where a party to a contract becomes entitled either to rescind it or to affirm it. As a result, some other, I suppose you might interpret that as neutral, but certainly the suggestion is it's the rights are contractually rooted, is the way he's analysing it there. And of course, he then goes on to say, but in my opinion, the same principle would apply where, as a result of the application of relevant laws, and in fact, such choice becomes available.
Clause 9.6 was about rescinding because the landlord doesn't give the licence within 8 weeks, wasn't it? That wasn't the basis of rescission here. It was because the title was voidable.
That seems to be what Lord Justice Stevenson is saying at the top of page 482. The right which the plaintiff seeks to exercise is the right to rescind an agreement made in ignorance of an irremovable defect of title. And then he goes on to refer to Lord Justice Slade. That seems to be what he is saying at the beginning of his judgment. So, whether or not the Clause 9 right could have been exercised, it's not entirely clear that it was being. And maybe that's because it couldn't.
Yeah, so let's just look at Lord Justice Slade again, which is to see if there's anything further to gain from a particular passage in that on this point. I think we've probably already been over this, but it's bottom of page 358, isn't it, where the circumstances in which the plaintiff's right to rescind arose are stated.
There's nothing there.
There's nothing there which
refers
refers
to numbers 1 to 5.
Nothing there which
about a right under clause 9.
No, it does. Clause 9 is not referred to there. So I think probably, I don't think I can say that, going back then
Right
to my original position, I was probably right first time, that
Don't want to mislead you.
not easy to see from the case, but it does look like on the face of it they were dealing with it as a right to rescind towards the contract. But our more fundamental point, I suppose, is twofold. One is that in all of the passages you can see that this is being viewed as being answered in accordance with ordinary principles of the doctrine of election and contract law. And you get that, for example, at Lord Justice Slade's judgment in particular at 498, just between A and B, the little marked paragraph. And our second submission would be that reading all of those judgments fairly, in our respectful submission, they're talking about a general principle which applies across the board, save of course with the statutory exceptions referred to, or where there may be certain evidential presumptions which arise on particular cases. And the right to rescind on the account of another party's breach will typically arise in cases where, as illustrated by this discussion of Claimant and Jani, where you will no doubt have overlapping arguments as regards whether or not the right to rescind arises from the contract or general common law. And in our respectful submission, it makes no sense to, in effect, lift out as a special category, which is simply those cases where the contractual right which you're invoking is on the basis that it happens to be spelt out in the contract rather than something which would be naturally to be taken to be a right which you get at common law. Perversely, on my learned friend's case, you're in a worse position if you spell out the contractual right in the contract, but not if it derives from a customary principle at law. What my learned friend hasn't made clear as well, he seems to be advancing the argument on the basis of this is just confined to express terms. So do we take from that it doesn't apply to implied terms? Or is he saying it applies to implied terms as well? Is the thrust, the force of his submission really to do with the evidential point that parties will ordinarily be taken to know the terms of their contract as an evidential one? And if it is an evidential one, are there the tools there for the courts to deal with it? In our respectful submission, yes. I was going through the judgment of Lord Justice Stevenson before we got into the question of exactly what was being exercised in terms of the rights in this case. I think the reasoning in relation to affirmation starts, as I said, at 481G in Lord Justice Stevenson's judgment. And even though it may well be that, as appears to be the case, that the right to rescind in this case that was being invoked was not clause 9 in the contract, clearly, in Lord Just Stevenson's mind, that is a source of a right to rescind, which is being viewed as part of the category of cases that is being considered. It would be very odd indeed if my own friend is right that this court was intended to, in effect, recognise and spell out an exception to that as part of the reasoning. In my respect for submission, that's an interpretation of Payman and Jani which just isn't there. The way he gets to that, as I understand it, is principally on two grounds. So if we go to the as I understand it, the principal basis for his submission in this respect, or the part of the judgment which he says has been picked up on by Hanley in the article. I don't think it's easy to see from Hanley that is where it's from, but it's the passage at the bottom of page 344 by reference to Matthews and Smallwood. And it's interesting to note there that in Matthews and Smallwood, the judge does talk about knowledge of the facts on which the right to re-enter arises. And Lord Justice Stevenson goes on to say, the necessary knowledge actually imputed are not being proved nor have the necessary action. No inference in favour of the second alternative, that knowledge of the right was necessary, can be made from the judge's references to knowledge of the breach. Because there was and perhaps could be no question that the lessor, and perhaps every lessor, must know or be taken to know of the right of re-entry given him by the express terms of his lease. Now, in our respect for submission, there are 2 points which are worth unpacking in relation to this. The first, before we just sort of deal with the words themselves, is the reading of Mr. Justice Parker's judgment in Matthews and Smallwood, because clearly Lord Justice Stevenson is contemplating that an inference might be drawn in favour of the second alternative, as he puts it, that knowledge of the right was necessary from the decision in Matthews and Smallwood. And it's worth briefly looking at Matthews and Smallwood to see those passages and in fact the decision on the facts. So if we can turn to Matthews and Smallwood, which is obviously earlier in time, and so hopefully we'll be in the same bundle, the relevant passage we're looking for is tab 5 of the authorities bundle. It's page 130. We see the passage which starts to be marked at 786. And the reason why Lord Justice Stevenson might have concluded that there was some that knowledge was just not simply restricted to sort of facts, but knowledge of rights is, I think, probably taken from the bottom of that page, where there's reference to if knowing of the breach he does distrain. And that's obviously coupled then with over the page knowledge of the circumstances from which the right of re-entry at that time arises. And obviously in landlord and tenant cases where there is knowledge of the breach, then the customary term of being able to re-enter or forfeit is obviously so well known that a landlord would be laughed out of court if they were to come to court, so they'd say they didn't know it. But it's illuminating to actually look at the facts of the case and see what the breach was here. So the breach here related to subdemise by way of mortgage, and you can see that from 788. And then you see the discussion of the sorry, I'm on page 141 of the continuous pagination. But you can see from the first main paragraph relation to subdemise by way of mortgage, and then you can see in the middle of that paragraph, the judge relies on the fact the only evidence he could find of actual knowledge on the part of the defendant Smallwood, there being a subdemise without his consent, was a letter written to him dated January 5th, 1906. And then he goes through the evidence in relation to that and Mr. Wilmot, who was representing the landlord. And if that's you turn on to that at page 790, you get an interesting discussion by reference to Mr. Wilmot, who was representing the landlord. It says, Mr. Wilmot, however, was, in my opinion, on the evidence, clearly in the position of the land agent surveyor. His duty was to obtain this principal offer, which Prince might either accept or reject. As a matter of fact, he didn't communicate again with his principal, that, etc. So he deals with the role of the agency, and then he deals with further with Mr. Wilmot's attention to the subject matter. And he goes on at 791. Says, I'm satisfied it was never really brought home to him that there had been a subdemise by way of knowledge at all. And even if he had been aware of that fact, it certainly was not brought home to him that there had ever been a breach of the covenant in respect to which a right of re-entry might arise. And it's those words which I've taken a rather long time to take your lordships to, but I think it's helpful to see the context. Which strongly suggests that in fact Mr. Justice Parker did have in mind that in this case he was treating breach as in effect coterminous with knowledge of the right of re-entry. So if we go back to Payne and Najani then, and the passage which my learned friend is referring to, in our respectful submission, if this is the foundation for the conclusion that in some way this was a recognition of a special carve-out, in my respectful submission, if you look at the underlying facts of the case which is referred to, you can see that if anything, Lord Justice Stevenson has probably underplayed the point as set out in Matthews and Small. And in fact, it looks like probably the reason why there's no real discussion of the separate question of knowledge of the right versus knowledge of the facts giving rise to the right. Because in the landlord and tenant context, once you have one, you probably have the latter. But let's also look at the language used at the bottom of 344. And perhaps every lessor must know or be taken to know. That's not the language of a judge who's recognising an express carve-out in relation to express contractual rights. In our respectful submission, that is consistently with the other passages in the judgment. The judge recognising that the different factual scenarios will give rise, in particular in the context of lessors, to some difficulties. We then get the substance of the reasoning over the page, where he refers to obviously the decisions Young, Bristol Aeroplane, Evans and Leithley. And obviously analysis of those authorities, and then the general proposition which then follows from that analysis of the authorities as concluded, if you like, on page 487. Now, 487, I think, was the next passage that the learned friend sought to place some emphasis on. In particular, before we get to G, where the judge holds that knowledge of the facts which give rise to the right is not enough to prevent the plaintiff from exercising that right. They must also know that the law gives them that right. Before that, there's a paragraph which, at the end of it, is rationalising the different lines of authority and the cases, and in particular, Evans and Young's. And then he goes on to say, election leads, I think, to waver whether in choosing to object or not to object to breach of contract or in acting in accordance with rules of procedure or statutory provisions. Again, general language is part of the reasoning across the board. And he goes on to say that common sense prevents landlords from saying that when they demanded rent from a tenant in breach of covenant, they did not know they had a right to retake position which they were waiving. And that obviously refers to David Blackstone Limited and Burnett's West End. And in that respect, what the judge is in our respectful submission seeking to do there is to recognise that in that context there may well be an evidential presumption as a matter of common sense proposition. And that's the rationalisation for David Blackstone that we say that he's giving to it.
You say in that context, do you mean specifically in landlord and tenant cases, or if not, then what is the context?
Well, you see it most clearly in landlord and tenant cases, and I think there's a judgment of Robert Walker's on the Ashworth case, who observes that you see some potential attenuation in landlord and tenant cases as a category. There are three potential rationalisations for that. One is simply as a matter of evidence and law that things are so customary that you just don't see the discussion of of knowledge of the right, because it's just so abundantly clear. The second is that in the context of forfeiture, the question of how that right is exercised where rent has been paid. If rent is paid and it remedies the breach, then that act itself probably remedies the breach if it's in relation to past rent. And if it's in relation to acceptance of rent for the future, you probably automatically have an estoppel type situation arising where someone will say, well, you accepted rent in relation to future occupation, you can't turn around and say, I have to get out. So the particular factual circumstances of landlords and tenant cases seem to compress, if you like, the discussion because of the particular circumstances of those cases. It may well be that in that particular scenario there's a particular tenderness to tenants as well.
The judge says a few lines below that.
Yeah.
That the principles on which one party to a contract is held to affirm it so that he cannot repudiate or rescind it are not peculiar to forfeiture of leases.
So he doesn't
seem to think that it's
no.
a point about the law of landlord and tenant.
No. I think probably he simply views it as, and this is I think our best rationale, he simply views it as a strong evidential presumption which arises in those cases, because the term is so obvious and customary. The whole judgment is not seeking to silo landlord and tenant cases, but seeking to rationalise them in context of the overall doctrine. And in our respect for submission, it's no coincidence that he also talks about legal advice presumption within the same paragraph. So, in our respect for submission, whilst I think probably I have to stick to my original position that this isn't per se a contractual rescission case, the reasoning underlying it all is the doctrine applies across all these different categories of case, and that's why, and that's how they reconcile the different authorities. And that's not a novel proposition in our respect for submission. That's the understanding that's been given to Claimant and Rajani in all the textbooks and all the cases that we see since in this jurisdiction. The only circumstances where you see dissent from that is people who actually just don't like Payman and Nanjiani and the proposition that it provides authority for. That's obviously, as my Lord Justice Mills has indicated, that's obviously not a submission open to my own friend before this court. So, my Lords, we would say that that the whole tenor of that is in support of rejecting submission of Mr. Riley, but it's also illuminating the bottom of that page to see after the statement of principle of G, there's the endorsement of the fact that a plaintiff can rely on their unchallenged ignorance of the law. Of course, it may well be challenged, but ignorance of the law as found. And then he goes on to say, unless he's precluded from doing so either by what he's done or by his solicitor's knowledge of the law. So there are relief valves there. And those are the relief valves that he then goes and discusses below there. In effect, this is the discussion leading to the second question. And you see then over the page, the use of the word precluded is used in the context of the estoppel at the top of page 488 between A and B. Now, there are a couple of passages, I think, which are briefly worth going to in the context of the question of, just check my notes, as time's marching on. Yeah, a point my learned friend seeks to make, I think, also, a sort of third point I think he seeks to make by reference to Payman and Nanjiani, is the endorsement of coastal estates. And so he says, ergo, in effect, as endorsement of coastal estates approach in this case. I think you probably already have our submissions on this and our written argument, but of course, in coastal estates, the particular passage which we see references to that most clearly are in Lord Justice Stevenson's judgment. I think it's at 488H.
I don't think so.
That may be
Perhaps 489A.
489A, so I think it's a little bit too early. So 489A. So where you see the grateful adoption of the statements of principle in relation to coastal estates is by reference to the estoppel part of the judgment. That acts adverse to the defendant. And in particular, for example, if you look at the passages quoted by Lord Justice Stevenson, the bits that are being endorsed are the general principles which support the general principle endorsed in Payman and Nanjiani, not the passage that my learned friend seeks to draw on based on which is an overture passage in Herring, Chief Justice Herring's judgment, which was put in most tentative terms by the judge in that case. Likewise, the passage in relation to Scholl and Adams. I think we've already been over the passage specifically quoted from by Lord Justice May already, and probably no need to go back to that. But we see the reason why that we see the endorsement in Palin and Jani is support for the general proposition which they recognise there in relation to the general conduct. And this is viewed by them as being based on ordinary principles of contract law. Indeed, stated so in turn by Lord Justice May at 498A. Let's just briefly then move on from Palin and Jani, unless there's anything further that your Lordships wish me to address on the points raised. But I think you have our headline submissions on it and some of the forensic points which we wanted to rule out. But we, in short, invite your Lordships to conclude that an essential part of the reasoning runs contrary to the submission made by their own friend, simply not open to it on the basis of Palin and Jani. And secondly, even if, as a matter of a tight definition of the ratio, you might say that it was dealing with a common law right to terminate. The language in it is, the reasoning in it is in our respect for submission, only consistent with a general recognition, also in a contractual scenario, it's a contractual termination provision. And moreover, the logic of my learned friend's submission is difficult to square with the idea that on his case we end up in this strange world of we're deemed to know our contract in terms of the termination provision part of it, but where the likely overlap scenario of termination, common law versus termination under the contract is overlapping. We end up with this very odd scenario of the first instance judges being required to undertake different analyses in terms of an overlapping factual scenario.
Can I just ask this about leases? Is there not a slightly different rule in relation to leases? That if you demand rent, knowing of the breach, that's sufficient to prevent you forfeiting?
In a sense of, in that scenario, you automatically must know them, mustn't you? In the landlord scenario context, that the rent which has not been paid, which gives you the right, you must in those cases be taken to know the right because it's so obvious.
Well, I don't know what the rationale is, but I'm asking the question,
yes.
is it not the rule in relation to leases that demanding rent with knowledge that there has been a breach is sufficient to prevent you then forfeiting on the grounds of that breach?
Well, that's the way that the landlord and tenant cases seem to proceed.
Well, that was what was said in Blackstone, which was 1970 something. The question is whether that survived Palin and Langiani, whether the rule in relation to leases is and always has been.
I think that the way that Palin and Langiani seems to rationalise, we respectfully submit, is the sensible rationalisation for it is in the landlord-tenant context, where it's a customary term that if there is a breach which entitles you to re-enter, is any landlord ever going to get off the ground the idea that they don't understand that gives them the right of re-entry? The whole context of the discussion is pregnant with the idea that you know that there's a right of re-entry or not. The more difficult question which might arise in that context is taken off the table by the observations in canons about not needing to know about legal consequences. So that part is the difficult part is taken off, but really there is no, it's difficult to see how there's any scope for debate in the landlord-tenant context that you will not automatically be aware of that from being a landlord and knowing the terms of your rights.
There's still a conceptual difference, isn't there, between a rule of law and a very, very strong evidential presumption.
Yeah, it obviously doesn't arise directly in this case, but it seemed to us that the sensible rationalisation for it is a strong evidential presumption. Whether or not, in effect, in reality, that amounts to the same thing. But if you are not siloing, if I can put it this way, leases into its own special category, I mean, the question of forfeiture of leases does give rise to certain different issues as well, because it's not just the relationship is not just contractual either. There's a species of property right which is associated with it, which gives rise to its own complications. And some of this, I think, is discussed in the Oliver Ashworth case, isn't it, by Justice Robert Walker, who talks about whether or not there may be some attenuation of the principle. So I think that's probably more in the context of reservation of rights scenario. Is probably what he had in mind in that case.
The question is whether there is in fact a difference. Although Lord Justice Stevenson says at page 487 D to E, that the principles are not different in contract and land. I've just had a quick look at what he's referring to there, and that's this passage which just says you can't have your cake and eat it.
Yes.
And that's the same throughout.
Yes.
There may be some technical differences.
There may be some technicalities which we haven't drawn out on this appeal to do with the forfeiture process, which involves also the fact that it's a proprietary interest. And but I think probably that our reading of Payment-Langiani, the one which we would respectfully submit, is consistent with it, as well as recognising the general principle is that it's recognising that in that factual context there really can be no debate. That's really what it boils down to. Rather than creating that would be our primary submission, I think. Secondary submission would be, for reasons that I've given, on payment or rent scenario, it's either curing the breach and therefore there is no fork in the road left, or it's a future payment in relation to occupation and it probably isn't a estoppel. It would only be if you went through that, you might then contemplate there's some sort of public policy or proprietary relationship going on there in the context of forfeiture, which obviously has its own special world in the context of forfeiture and provisions in relation to that of landlord and tenant. But our reading of the passages in Payment-Langiani is really they're saying, well, probably can't be any debate about this in this context. And our special submission, that's why in that category of cases, or lots of the cases, you just see discussion knowledge of the rights. And it would be very odd, if I may respectfully say so, to end up in a situation where the whole basis of the doctrine is the question of knowledge of choice. Yet you're chopping off from the person who is, in effect, the person who's losing the contractual right, the very thing which is key to them knowing they have that choice. The doctrine loses any connection with the concept of choice unless, as part of it, you either know of a choice, or in the blind knowledge cases, you suspect you have a choice. Whether that's whether the focus of the debate in that respect, or the focus of the case is on the facts giving rise to it, or the right itself, I don't think there's a distinction of principle there which is meaningful. And we would submit there isn't. We've concentrated heavily, I think, on this appeal because of obviously of my own friend's submissions on coastal estates and Sargent. Just a couple of brief observations before I move on to just one or two other points. The first is that in relation to Sargent, I think my own friend took you to one passage in Sargent, but actually there's another passage in Sargent which undermines his thesis, which is in the judgment of Mr. Justice Mason, where he basically says, well, this is a general doctrine and doesn't favour the idea that you can have a different doctrine for a carve-out for contract, if I can put it that way. And I don't know if your lordships have already alighted on that passage, but I think it's briefly worth taking your lordships to that. I probably don't need to take long on it, but it's in tab 42, which I think is in file 3 of your lordships' bundles. particular passage in Mason's judgment, which I was going to take you to, is paragraph 35 at page 1287. So I think the difficulty my lone friend has is that in reality, in Australia, sergeant is viewed as departing from coastal estates. I'll come back to just look at just a recent case in Australia which perhaps illustrates the difficulties of application that have been created by the way that the Australian law has gone. But if you go back to, as I understand it, the point which was mainly underlying the justification, that the good reason why this is all different. My understanding of my own friend's submissions was this was really based on the principle from Lestrange and Grocott, and he gets that from well, you can see it in the judgment of Mr. Justice Stephen in Sargent at paragraph 26. But what's said in paragraph 26 about Lestrange and Grocott is in fact wrong. And we would respectfully endorse what Lord Justice Miles has said, is that the principle in Lestrange and Grocott is not dealing with a deemed knowledge of the terms. It is dealing with something quite different. And if we can just briefly turn up Lestrange just to see what it is authority for, in the authorities bundle.
Just before you move off that, this is a silly point, but the first line of this judgment on page 1273 has ACJ McTiernan saying, I agree substantially in the reasons for judgment of my, and then Mr. Justice Stephen's judgment begins.
I think there may be some missing words.
Well, there are, and
yes.
it'd be helpful to know who he's agreeing with.
Yes, I think, like my lone friend, I assumed it was, but we'll check to see if we can. We'll check to see if we
Sorry about that.
No, it's a fair point. We'll see if there's a better
Yeah.
somewhere. So I was going to take you to Lestrange, wasn't I? Briefly?
So you said Lestrange is referred to in paragraph 26. I don't think it
Yes, paragraph 26 in can you see
Mr. Justice Stephen.
Mr. Justice Stephen. So he says he is deemed to know the terms of his own contract and the right it confers. And then there's reference to Lestrange. Can you see that? So at page 1278 of the bundle.
The numbering starts again, so it's not.
it starts again when you get to a new
To a
judgment.
new
Yeah, so it's
so
not.
Mr. Justice Mason.
It's not.
yes.
Sorry, it's not a very user-friendly report.
Oh no, I see. I have actually marked the right one. Yes.
It's 1278.
Thank you. I think there was a time when our judgments did that, but happily that was
Yes,
correct.
no, it's a little bit confusing.
My error. Thank you very much.
So that seems to be the sort of the fountain for this particular argument. But in our respectful submission, it's just simply based on a fallacious reading of what Lestrange and Grocott is authority for. If you go back to tab 6, it's in folder 1, I think, or file 1. And you can see, obviously, the holding is someone is bound by the terms holdings at 395, whether they're bound by the terms of the contract, and it's immaterial whether they've read it and did not know its contents. It's dealing with a very different proposition of principle. And it's in effect following on from the discussion in Parker and South Eastern Railway Company, where the ticket cases at the bottom of page 158 and over the top, where again it's not reading or knowing the contents of the terms. And what the court is saying is well, you're bound by the terms as a matter of contract, whether you've read them or understood them or not. Similarly, sorry, that was Lord Justice Scrutton's judgment. In Lord Justice Morgan's judgment at 406, you get the same point.
I mean, Lord Justice Morgan goes a bit further and says it's immaterial to the question of his liability under it, that he's not read it and does not know its contents.
Yes. So it's irrelevant to the question. It's not a question of, as a matter of law, we are deeming you to have knowledge of this. It's simply saying it's irrelevant. We approach this. The contents of a contract are objective. They're objectively determined. There's no deeming of knowledge. It is not the logical consequence of one rule. All the terms in the written document I have signed are incorporated into my contract, that the other alleged rule should follow. I'm taken to know for the purpose of waiver by election all my rights in the contract and their significance as interpreted by the court. Put in brackets as an aside, in this case, actually what the other party were arguing was the proper interpretation of the contract. So there's no contradiction in our respectful submission between the propositions. I'm bound by my contract, and I did not myself know the contract contained that right. I think it's also worth briefly going back to a first instance judgment in this jurisdiction, which also deals with this point. I think it's Mr. Justice Mann in the pubs case. I don't think we've yet gone to that. And this is, just give me a few moments to find it, but I think it's decision 2017, so it's at tab 29. $890. That's right. So, sorry, it's in your lordship's bundle of folder 2.
Yeah, tab 28, I think.
Tab 28. So my apologies. I think from the electronic, some of the tab references might have gone a bit off. Now, this was an election case which also involved an express contractual provision. You can see that from paragraph 9, which starts at page 892. And then paragraph 10, you can see the clause which is the focus of attention. So one of these cases where there's an option given to, in effect, the landlord in this case to acquire in certain circumstances under the terms of a particular lease provision. And you can see that the trigger letter, which is said to be relevant for present purposes, in paragraph 16. Which refers back to clause 12(1) of the lease. And the option, in effect, the landlord to purchase the property at a proposed price of 1.7 million. And then you can see in paragraph 17, that's the letter relied on by the administrators as triggering, as being the triggering of the landlord's buyback right under the option clause. And then you can see paragraph 22, there's then the response to that trigger letter, which is in effect treated as the affirmation letter, where you can see that the question mark is taken as regards whether or not the notice is properly being served, but then subject to that formality being reserved, however, the purpose of the letter is to let you know my clients have no objection in principle to the proposed assignment release conditional on, and then certain matters are set out as regards conditions of the assignment. And you can see then the question of waiver or election arises in paragraph 24. Or is dealt with in paragraph 24. The administrators were submitted if contrary to their case the trigger letter is not sufficient to comply with the condition, then the letter waives, the letter being the second letter, waives any defect and elects not to buy back the lease. We can see the issues for decision was summarised in paragraph 30. And then if we see that one of those was whether or not girdlers had waived their right to buy back the lease in little d. And then we have the discussion about waiver in relation to the buyback right at paragraph 68. And you can see that in this case, the point seems to have developed as the trial went on as a point of importance. There's a summary of the different contentions by the parties in terms of the battle lines. And then there's a summary of the different types of waiver in FLACA. There's unilateral waiver and waiver by election, which we don't need to dwell on here. You then get to 74, which summarising the principles in relation to election and then reference to Kanchenjunga at 75 and Payne-Lajani, and acceptance that Payne-Lajani was obviously binding on this judge. And then we have the submissions. Mr. Greenhill, that notwithstanding, the assessment of knowledge had to be conducted on what he called an objective basis, and that submission was rejected. And you see within that passage, knowledge for these purposes means actual knowledge. It is not the same as contractual intention. So there we see recognition of in effect, that it's the same point that I was making a few moments ago about the difference between the two doctrines as recognised by Mr. Justice Mann. Obviously, on the facts of that case, he then analysed whether or not there was or wasn't a waiver. And the application, so he concludes his the submissions as in effect as an attempt to read down Payne-Lajani, which is rejected by him. And the conclusion of the general principle in paragraph 78, that the inquiry is in effect a jury one. And then we have at 79 application to the facts, and as it happens, he concluded, subject to one point, that knowledge would that the knowledge acquired would be sufficient. And you can see that really in the passage from 88 onwards. the main point, concluding point, is at the end of paragraph 19 on to 91. But then there's a further interesting discussion in it, because there was a further point that was then being made, which was that the knowledge part of the case was acquired through a process of being told certain information which was materially erroneous. And the judge rationalised that submission at paragraph 94 and 95 as in effect being a submission that even if you would otherwise treat me as having relevant knowledge, there may be grounds upon which the court could conclude that knowledge has been vitiated. Now, if contrary to my primary position that my learned friend's submission on this is all wrong as a matter of law, this court were to uphold and endorse the notion in a contractual context setting someone is deemed to know, the further question would then arise, is there a basis on which it might be said that we can in some way seek to vitiate that on the particular circumstances of this case by reason of the fact of what we were told about the context of the amalgamation, etc. That's obviously something wasn't we explored in the trial below, because it wasn't a matter which we needed to explore, because at first instance it was common ground that the key inquiry was a factual one as regards what Mr. Ensor knew and believed. But if this point had been taken by my learned friend, logically it would have been taken in the pleading and would have been addressed in the summary judgment application by Mrs. Justice Mulder, because the proposition he's advancing is in effect a proposition of law which he says disposes of the three-day factual inquiry we had. And it would have been disposed of one way or the other at that. And then we would have turned our mind to, well, okay, what as to other ways we can seek to attack this? And one potential juridical basis that's being identified here by Mr. Justice Mann is that in some way that may be vitiated in certain circumstances where the stance you've taken is induced in effect by what you're told by your counterparty. Now, I'm just simply highlighting this as one of a number of different things that might have been looked at. And I've saved, I suppose, into my submission in relation to, can we simply say that the inquiry which is undertaken in this case was simply one of law, and nothing would have been different at the trial but for that inquiry. And this is one illustration of why we'd say that that's not so.
I'm not sure I quite get that point, Mr. Sims. Your client was told of the amalgamation, and then, as it were, the point passed. And your defence, part of your arguments have been, well, your clients didn't then think about it, and that's all to do with knowledge of waiver point. But what possible argument could there be that you'd been misled about that point, and they told you about it?
Well,
you then effectively put it to one side. Because
well, obviously this wasn't explored, but there were oral discussions between the parties about what the effect of the amalgamation was going to be. And one of the things we could have explored was the extent to which the stance adopted by Mr. Ensor in that respect was induced by representations that NHG made to him about the consequences of the amalgamation, because they were seeking to contend nothing changes, this is all as it was before, which is in fact arguably on one interpretation of the facts wrong. And to the extent that my own friend gets traction on any of these other points, relation to, we simply flagged this as a potential area we would have potentially been looking at. I mean, there are all sorts of other arguments about the fact that the whole course of the litigation would have been different because we wouldn't have had the examination at trial of Mr. Ensor. Modern cases, obviously, a company case like this where it's insolvent, there's all sorts of funding arrangements in place. How do you unravel all that? But the reality was that this wasn't an argument which we thought we were going into trial to meet. We thought we were going into trial on the basis of the key factual issue here is what did Mr. Ensor know or not. And that's the way on which the trial proceeded. And what I wouldn't want your lordships to think is that, well, this is just it's a simple point of law which in effect wouldn't have potentially had a different outcome in terms of the exploration of the evidence. The point itself is a point of law, and so therefore I don't quibble with that proposition. But, we respectfully submit that it's too simplistic to say that the inquiry would stop there, even on a sing and das basis. And I think you have my additional submission about no proper explanation as well.
Yes.
So I've lost track of time a little bit.
Right. Well,
your lordships, I think, indicated that perhaps
yes.
you wanted to.
I mean, if we were to stop now, I suspect you'd still be in good time to finish within your allotted time tomorrow. Is that right?
Yes, I think so.
Okay, well, in that case, I think we will. So we will adjourn until 10:30 tomorrow.